If there is one part of a deed that you should never gloss over, it is the granting clause. The granting clause is the engine of the deed. It is the language that actually transfers ownership. Everything else in the document supports this clause, but without a valid granting clause, there is no conveyance. What is the granting clause? The granting clause is the portion of the deed where the grantor formally transfers an interest in the property to the grantee. This is where you see words like grant, bargain and sell, quitclaim, convey, and warrant. These words signal what type of deed is being used and what promises, if any, are being made. Courts, title companies, and recorders look to the granting clause to determine whether a transfer actually occurred, what interest was conveyed, what covenants are implied or excluded. If the granting clause is missing, unclear, or inconsistent with the rest of the deed, the transfer can fail, even if everything else looks correct. Granting language must match the deed type. The title of the deed must match the granting language inside the document. For example, a grant, bargain, and sale deed must use granting language consistent with that form. A quitclaim deed must clearly disclaim warranties. A warranty deed must contain language supporting the warranties being offered. Mixing and matching language creates ambiguity, and ambiguity is the enemy of good title. The granting clause does not define tenancy. The granting clause transfers ownership, but it does not define how multiple owners hold title. Tenancy language belongs elsewhere in the deed and must be stated clearly. Do not rely on the granting clause to imply survivorship or ownership percentages. Here are some examples of granting clauses. First, in a grant, bargain, and sale deed, the core granting language will say, does hereby grant, bargain, and sell. Used in a sample granting clause, it might sound like this. John A. Smith does hereby grant, bargain, and sell to Jane B. Smith, a married woman, as sole and separate property, the following described real property. What this language does: it signals a grant, bargain, and sale deed. It creates implied covenants under Nevada law. It transfers ownership immediately, and it makes limited promises about the grantor's actions. Those words, grant, bargain, and sell, are doing legal work. They are not filler. Here's a sample granting clause in a quitclaim deed. John A. Smith does hereby remise, release, and quitclaim to Jane B. Smith, a married woman, as a sole and separate property, title and interest, if any, in and to the following described real property. This language signals a quitclaim deed, transfers only whatever interest exists, makes no warranties or promises, and explicitly limits grantee protection. Note the phrase, if any. That's the quitclaim disclaimer. Next, here's an example of granting language in a general warranty deed. John A. Smith does hereby grant, bargain, sell, and convey, and does hereby warrant to Jane B. Smith, a married woman, as sole and separate property, the following described real property. What this language does: creates broad warranties, covers the entire chain of title, and exposes the grantor to long-term liability. Warranty language expands risk. That's why it's used intentionally and sparingly. Here's an example of special warranty deed granting language. John A. Smith does hereby grant and convey and warrants only against claims arising by, through, or under grantor to Jane B. Smith, a married woman, as sole and separate property, the following described real property. What this language does: it limits warranties to the grantor's ownership period, excludes prior title defects, and is common in commercial or entity transfers. Next, granting language in a transfer on death deed. John A. Smith hereby transfers on death to Jane B. Smith, a married woman, as sole and separate property, the following described real property, effective upon the death of the owner. This creates no present transfer. Transfer occurs only at death and is subject to statutory limitations, including the creditor hold. Common granting clause mistakes are issues that should always trigger a careful review. Missing or incomplete granting verbs, granting language that conflicts with the deed title, warranty language appearing in a quitclaim deed, inconsistent references to the parties, These are drafting errors, and they're avoidable with attention and consistency. As a document preparer, you may use statutory or approved granting language. You may ensure internal consistency. You may not alter granting language to change legal outcomes. If a client wants to modify granting language beyond standard forms, that requires attorney involvement. Big takeaway for this section. The granting clause is where ownership actually changes hands. If it's wrong, nothing else matters. If it's clear, consistent, and appropriate to the deed type, the rest of the document can do its job. In the next section, we'll talk about legal descriptions, where they come from, why they matter, and why you should never try to rewrite them.
This video is provided for general educational purposes only. It is not legal advice, and it does not take the place of advice from a qualified attorney. Laws and requirements vary by jurisdiction and by individual circumstances, and watching this video does not create an attorney-client relationship with Nevada Counsel. If you need guidance about your specific situation, you should consult a licensed attorney in your jurisdiction. Thanks for learning with us.